Part heard appeal in the matter of beginning on the application of Andrew Boswell and the Secretary of State for Energy Security in Net Zero and others.
Yes, Ms. Grogan. There's a note.
Yes, my lords. There is an agreed note on the transitional arrangements for the Energy National Policy Statements. Would you like me to take you through that briefly? Or invite you to
would
read
it help if we just scanned it just to see what's there rather than digesting it closely?
And that approach by the Secretary of State is not contentious?
No, my lord.
Content?
Yes.
No, that's very helpful. Thank you very much, all of you, for doing it.
The other piece of homework I set myself yesterday was to check whether the IEMA guidance refers in terms to well-to-tank emissions. And the answer is it doesn't, but it does. We looked at that reference where it refers to life cycle assessment.
Right, so do we need to be concerned with well-to-tank as a concept?
No. Only insofar as it was one of the issues of the examination where the examining authority and the Secretary of State ultimately accepted Dr. Boswell's position that they needed to be assessed.
Right. Well, thank you very much for that as well.
So picking up from where we were yesterday, we were looking at what was decided on the topic of greenhouse gas emissions. I'm going to take you to the examining authority's report and the decision letter because some of the detail is important, and then make some very brief submissions on the grounds of appeal, drawing all the threads together.
Yeah.
When looking through the examining authority's report, the basic submission I am making is that the examining authority's express references to the IEMA criteria need to be viewed in context because they were addressing the separate question of what do you assess, what's the scope of the environmental assessment. The examining authority did not apply the IEMA criteria when assessing significance. When it came to the decision letter, the Secretary of State was not picking between the appellant's case on IEMA and the interested party's case. It was also, the defendant was expressly agreeing with what the examining authority did, which I'll show you in a moment. As a matter of principle, the Secretary of State was of course entitled to reach whatever judgment she wished to on significance, but what actually happened was an agreement with the way in which the examining authority had done it.
Could you just, you've got a bit of unfair competition and my hearing's not very good, so
I'll speak up.
Could you just do that a bit more?
Yes, so when it came to the decision letter, as a matter of principle, the Secretary of State was not bound to select between the rival contentions of Dr. Boswell and the interested party. What happened was that the Secretary of State agreed with the examining authority's assessment, which itself was not an application of the IEMA criteria.
And if the Secretary of State had been applying the IEMA criteria, that would have been a relevant controversial issue, given that he wasn't. So it wasn't.
Yes. Going then to the examining authority's report, that's at supplemental bundle, page 176, and it starts at 5.3.
Right, you want us to
We'll turn that up,
go
please.
there?
What I'm going to do first is just look at some of the headings to show you what the issues were and point out references to the IEMA guidance. I'm hoping to take that relatively quickly.
Right.
And then I want to spend a bit more time on the examining authority's actual assessment of significance. So if you look on the left-hand side, you've got the heading climate change, That's on page 176. Policy considerations then summarises the requirements of the national policy statements. And then the examining authority goes on to summarise the parties' cases on the assessment of greenhouse gas emissions. You see that over the page, at page 178, there's a heading which summarises the applicant's case. And then on page 179, a heading, Examination Matters. And you'll see the first topic there is life cycle greenhouse gas assessment. The issue is set out at 5.3.26 and 5.3.27. And I'm summarising here. The appellant's position in the examination was that the full life cycle had not been assessed, and it ought to be. The interested party's position was that version 1 of IEMA didn't say you had to do that, but that following IEMA version 2, it accepted that that was best practice, and so it updated the assessment. So that's where you get some references to the IEMA guidance in those passages. Over the page onto 181, you see the next topic, cumulative assessment. And again, you see the issue summarised at 5.3.36, which was the appellant's point that a cumulative assessment needed to be carried out with reference to the IEMA guidance on cumulative assessment. Naturally, you see quite a few references in those passages to the IEMA guidance, because that is the point that Dr. Boswell was making. He said you need to do more than just a comparison with national carbon budgets. You need to look at this development in combination with other developments. And that is a point that, as an aside, has been resolved in other litigation in the Dr. Boswell case in the Court of Appeal. If you move over onto page 182, you then see the examining authority's response. There's a heading halfway down the page where the examining authority then gives its views on these issues. And again, we have references to the IEMA guidance here. 5.3.43 we looked at yesterday. That's a point about resilience. Not relevant here. 5.3.44, this is a passage that the appellant puts particular reliance on. It refers to the fact that the IEMA guidance was referenced by the applicants and that it wasn't disputed by interested parties that that was a suitable approach. And the examining authority were content the guidance is appropriate for addressing the requirements of the ES. I place emphasis on those words because of what follows, because the examining authority then goes on to explain that a part of the update to version 2, the applicants accepted that the assessment should include upstream and downstream emissions. So that's the life cycle point. And the last sentence, the examining authority are satisfied that this assessment is appropriate. So that paragraph in my submission is dealing with the Chapter 5 question, what do you assess?
What do you bring into account?
Yes. Then over the page to 5.3.46. In my submission, this is a very important paragraph. I don't think we've looked at it yet.
5346?
Yes.
Well, I've put a sideline against it, so I think it may have been touched.
Possibly. I don't have a marking, but that might just have been I missed it. I would like to look at it in some detail.
Right.
5.3.46 is of note that the draft EN1 describes the inevitable emissions that cannot be avoided from some energy infrastructure as significant adverse impact. EN1 does not provide policy on this matter. We also note that the reference to IEMA is quoted as saying that all GHG emissions are classed as having the potential to be significant, as all emissions contribute to climate change. So that is a reference back to IEMA's in-principle position that you see in both version 1 and version 2 of the guidance. Given there would be approximately 70 megatons, that's accepted to be a typographical error. that number.
Yeah.
It should be 16, I think. There's an errata. There was in the High Court an errata sheet.
Yes.
Which corrects that as common ground, and that needs to be corrected. But given there be approximately large amount of carbon emitted, even with 90% capture, we conclude that this would be a significant adverse effect. So my submission, what the examining authority are doing there is they're saying that's a lot of carbon, put in context of national policy and the IEMA guidance, which accepts that carbon emissions are significant. In coming to this conclusion, we have had regard to the applicant's use of the UK carbon budget in section 21.3 of the ES chapter 21 to put these emissions in context and accept that they would be a very small part of this. That's a reference back to the comparison the interested party carried out with national carbon budgets. And the simple point being made there is, if you compare this to carbon budgets, it's not a large percentage of the total carbon budget, but nonetheless, for the reasons given earlier in the paragraph, it's a lot of carbon. And the value judgment we, the examining authority, place on this is that it's significant.
Yeah.
Over the page onto 184, you then see the examining authority working through the next stages of the issues. And at 5.3.51 and 5.3.52, they're dealing there with the cumulative assessment point. And resolving that issue against the appellant, where they conclude at 5.3.52 that the applicant did follow the IEMA guidance on cumulative assessment. And the issue there was, can you carry out a cumulative assessment against any other metric? The examining authority thought, well, maybe you could on a sectoral basis, but accepted the argument from the interested party that actually there wasn't enough information to do that. And then 5.3.53 completes the picture on that topic, which is draft EN1 suggests because operational emissions would be managed in an economy-wide manner to ensure consistency with carbon budgets net zero and international climate commitments, individual applications would not need to be assessed against these measures.
Yeah.
And then you have 5.3.55 through to 5.3.59, the examining authority's conclusions. And at 5.3.57, you have the conclusion on significance, which you have to read together with 5.3.46. And there they reference the correct, at the time, figure for the amount of carbon over the lifetime of the proposed development, and say, based on the policy in draft EN1, we conclude that these would have a significant adverse effect on carbon emissions, even with CCS. They refer to cumulative emissions and also consider that would be significant adverse. And then they give those conclusions moderate weight for the reasons set out there.
So that runs together in the same paragraph, the question of significance and the question of weight.
Yes. In between, so that's the examining authority's report. And
just before you leave that report, can I just be clear about 5353?
yes.
Page 184, the reference to managing operational emissions in an economy-wide manner. Is that a reference, I mean, that's referring to the draft EN1,
Yes.
but by the time the decision letter comes out, you see a similar reference. Is that a reference in the 2024 EN1 to what we see at page 356 of the supplemental bundle? Paragraphs 5311 and more particularly 5312.
Yes, it is. Yes, so the point on managing in an economy-wide manner applies to both the individual assessment of the scheme's carbon output, but also the cumulative assessment. And it just so happens in some cases, as was the case in Dr. Boswell's last trip to the Court of Appeal, sometimes you can do that assessment, the cumulative assessment, by comparison with national carbon budgets, in the same way as you do the individual assessment, as the Court of Appeal held that calculation could work for both aspects. Because the national carbon budget is itself cumulative. That's a very crude summary of what Boswell.
But as I'm saying, what national policy is saying is, well, you might decide to compare to carbon budgets or some other metric, but in this instance, it's being handled by management across the economy.
Yes.
With the links to UK ETS and so on.
Yes, so you might do it that way, but you don't have to.
Yeah.
Yeah, that's what the policy is saying.
Sorry.
So continuing with the chronology, in between the examining authority's report and the decision, you get further rounds of consultation. And this is the point at which you get Dr. Boswell's submissions on the basis of IEMA section 6 that we looked at yesterday. That's at page 190 of the supplemental bundle. It starts at section 7 on page 217, under the heading IEMA. And again, with reference to the bold headings in italics, you can see the points he's making.
Sorry, page?
I'm on page 217,
Thank you.
about halfway down the page.
Yeah.
So his first point at 7.1, just the heading, incorrect claims for the counterfactual, that's the point you heard about yesterday, which is, should you compare this to unabated or not? 7.2, there's then a heading, IEMA contextualization, sectoral reduction strategies. Here, Dr. Boswell refers to the point that I'm summarising that IEMA make, which is that you start with a percentage contribution to the national carbon budget, but sometimes that doesn't tell you very much because most individual projects' contribution will be small. And then Dr. Boswell is making a point that contextualization should be done with regard to sectoral reduction strategies. If you turn over the page to page 219, he also makes his point again, paragraph 116, that this project should be assessed cumulatively with other schemes coming forward in the UK, such as the Drax-BEX project and another carbon capture project.
The Drax-BEX project was the subject of the client.
The Drax-BEX project came later from the Client Earth Court of Appeal, so it's the same power station, but they applied for a development consent order
For a different
to become carbon capture ready.
project.
That was challenged, but permission was refused.
Yeah.
7.3 on page 220. Dr. Boswell then has a heading, IEMA contextualization, existing and emerging national and local policy or regulation. That is a point where he says, when contextualizing, you need to look at national policy. His specific point is not that you should look at EN1. He's making a point about delivery risk to the net zero strategy, which has come up in other cases. And then page 221, 7.4, IEMA summary. He's making the points again, they've used the wrong counterfactual, they should look at fuel sector emissions as the comparator, and that is his big point at paragraph 100, if we skip over to paragraph 140. And 8.3 on page 224, summary on significance assessment, and then you were taken to these paragraphs yesterday. paragraphs 145 onwards. And the points he's making there are quantum of emissions is significant if you compare them to the fuel sector residual emissions for the 6th carbon budget. Over the page on 225 at 147, he says they're major adverse in IEMA terms because of the impact of upstream emissions on the NDC from the Paris Agreement, and 2, uncaptured direct emissions and transport and storage unavailability, so that's TNS unavailability, when compared to the power supply sector. And 148, he says that poses serious risks to the UK NDC and Carbon Budget 6. And his point on the law was that, taking all that into account, you shouldn't apply the NPS pursuant to the exceptions in Section 104 of the Planning Act, because he was saying it would put the government in breach of its international obligations. What he's not doing, in my submission, is ticking off the IEMA criteria in Section 6 of the IEMA guidance. He's making a number of different points.
Is that a reference to page 116?
Yes, that's a reference to page 116. Focusing specifically on his preferred method of contextualisation, which is look at the contribution to fuel sector emissions. So it is not as straightforward, in my submission, that the case being presented to the Secretary of State was a binary choice between the interested party's application of page 116 and an application by Dr. Boswell of page 116. It's more complicated than that.
Does he address the question whether the scheme is consistent with or supportive of the overall net zero target?
He says at 148 that it's not. He's effectively saying no, it's not, because it takes up too much of the fuel sector budget, and therefore it puts compliance at risk.
Well, it takes up too much of the
The fuel sector contribution. It's not
to CB6.
To CB6, yes. So the way it works, and Dr. Boswell acknowledges this in this submission, is that when they do the carbon budget delivery plan, they break emissions up by sector, and they identify the savings that each sector should seek to achieve. Well, Lord Justice Holgate might remember this from Defence of the Air.
A little bit.
They aren't sectoral targets, they're not binding, but Dr. Boswell uses...
These are the pathways.
Pathways, yes.
Yes.
Yeah. Dr. Boswell used those to say, the government's position is they need to achieve X amount of savings in Carbon Budget 6 for the fuel sector. If you compare this project's emissions to that, you see it takes up 5% of those emissions, which in his submission was significant.
Well, is the larger point there that it's therefore not compatible with the trajectory to net zero?
Yes, that's his point.
But he doesn't quite go that far, does he? He says there are serious risks.
Yes.
But he does not assert as such that it is incompatible.
Yes, that is what he says.
Yeah.
I've gone too far there. You're right.
Yeah, quite right. That's the language he uses in 148.
Yes, serious risks.
Right.
If we go now to the decision letter, we can see how all of that was grappled with. That's at page 422 of the core bundle.
Are we putting away now the
Putting that all away.
Dr. Boswell's submissions?
Yes.
And we're going now to the decision letter.
Yes.
Yeah.
I want to pick up the decision letter at page 422. We looked yesterday at the conclusions on need, which immediately precede this section. So the structure goes need, then climate change. So in terms of the thought process, the Secretary of State has just concluded that the project will help achieve net zero, and now moves on to look at climate change. The paragraphs in this section also follow the structure of the examining authority's report that I took you through. And reflect, you can see it, tick off the paragraphs in the examining authority's report that we looked at about 10 minutes ago. So you have 4.3.2, which is the reference to resilience. 4.3.3.
433.
Yeah, sorry, 433. That is a reflection of 5.3.44 of the examining authority's report, which is the what do you assess life cycle question. And there's a reference there, the examining authority was satisfied that this assessment was appropriate.
Forgive me, where are you looking?
I'm looking at the very bottom sentence of 4.33. Sorry, yeah, 4.33. So that is a reference back to the life cycle issue and the examining authority's conclusions on the life cycle issue. 4.3.4 is dealing with the point that was raised in the examination about emissions factors and carbon intensity. And you see again the same reference halfway down the page that you were taken to.
In respect of GHG
Exactly.
emissions, yeah.
Yeah. And again, a cross-reference back to 5.3.44. So addressing the question of what you assess.
Well, those are the two particular sentences on which the appellant was placing particular reliance.
Yes. Yes, and my submission is they need to be read in their context, which is they're dealing with a different point. They're not dealing with significance. .3.5, you have at the bottom the first reference to designated EN1 and the 2021 and 2023 drafts. That's at the bottom of the page. That's in the context.
Can I raise a little whinge?
Yes.
Why don't you call it 4.35?
I don't know. I will start calling it. I think it's because I'm in the rhythm of the examining authorities report. I will stop and you can throw something at me if I keep going.
End of whinge.
That's fine. Whinges are welcome.
That's a good. We must remember that. Whinges are welcome.
Yes.
Can I have that in writing?
I'll put it in every skeleton from now on.
Yes, pre-reading list. Yes, and whinges are welcome.
Yes.
Right.
So that paragraph, 4.35, is dealing with the unabated issue and the agreement that the proposed development would emit approximately 20 megatons during its operational life. And at that point, the Secretary of State notes national policy. .36, the Secretary of State, which is over the page, then refers to IEMA's principal point, which was also referred to in the examining authorities report, that all emissions have the potential to be significant and contribute to climate change. Then there's a reference to the examining authorities' conclusions that these GHG emissions would have a significant adverse effect. And an accurate summary. In coming to this conclusion, it had regard to the applicant's use of the UK's carbon budget in section 21.3 of the ES to put these emissions in context and accepted they would be a very small part of this. And there's a cross-reference there to the bit of the examining authorities report, 5.3.46. My very important paragraph.
Yeah.
4.37, the Secretary of State then goes on to deal with representations by SEP during the examination. This is about carbon intensity. I just want to draw your attention to the last sentence, which refers to the examining authority being satisfied that the applicants had taken all reasonable steps to reduce greenhouse gas emissions during construction operation decommissioning, as required in the draft 2021 EN1. That's important because that conclusion is inconsistent with an application of the IEMA criteria, which says a major adverse is business as usual or due minimum. This was not a due minimum project.
But it's inconsistent with an assertion that the phrase was used in the sense meant by the IEMA guidance.
Yes. Uh, 4.38 is the cumulative point. 4.39 is the, again, addressed in an economy-wide manner point, so they reflect those passages of the examining authorities report we looked at where cumulative emissions were addressed.
But it also cross-refers to 5312 of the
Yes,
current EN1.
yes, which we looked
It
at.
makes the point, following, if you follow that policy, you don't need to assess against carbon budgets for this type of project,
Yes,
given its nature.
yes. 4.41 on the right-hand side of the page at 425 is another reference back to the examining authority's conclusions. And again, that mirrors the examining authority's points. One, it's over 60 megatons of carbon over the lifetime of the proposed development. 2, based on draft EN1, that's a significant adverse effect, even with deployment of CCS. 3, cumulative is also significant. This finding was given moderate weight in the planning balance on the basis that it was based on draft policy. And then again, another accurate reflection of the examining authority's conclusion, accepted that in isolation wouldn't measurably harm the government's ability to meet national targets or have a significant effect on UK carbon budgets, and then a cross-reference to where the Secretary of State's conclusion is set out. That's, we can skip ahead to that, which is 4.56, which is on 429. 4.56 deals with SEP's double counting error and arrives at the figure that was ultimately accepted as being the right figure, the amount of carbon, which is plus 20.
Yeah, I mean, it deals with SEPs pointing out the double counting error.
Yeah. And accepts that there was one and accepts SEP's figure. At the bottom, last sentence, she agrees with the examining authority that greenhouse gas emissions from the proposed development itself must result in negative weight. And then over the page at 4.58, you have the overall conclusion on climate change. And breaking that down into its constituent parts, the Secretary of State's considered the examining authority report and consultation responses. She considers that the proposed development would support the UK's transition towards a low-carbon economy. So that's point 1, which is reflected in 4.11 of the decision letter that we looked at yesterday, and all of that analysis, this project will help.
I mean, put bluntly, that is an impossible sentence if the appellant is right.
Yes. And that is relevant because
Yeah.
one is supposed to read this sensibly and fairly. And
But I mean,
as a whole.
it can't be suggested it's there by mistake.
Nope.
And is not suggested it's there by mistake.
No. And it's very much not, because there are many paragraphs earlier in the decision letter explaining why that conclusion has been reached. The next sentence is consider the potential benefits which the wider project would bring in reducing emissions, but accepts the examining authority's conclusions that over the lifetime of the proposed development, emissions would have a significant adverse effect. So that is harking back to the examining authority's significance assessment, which is it's a lot of carbon. It's not very much of the carbon budget, but national policy and IEMA both say any emissions have the potential to be significant. And then she goes on to address weight in the next sentence, doesn't agree it's moderate weight, refers to national policy again, and then identifies the things that have changed because she's disagreeing with the examining authority and therefore has to give reasons. Identifies the things that have changed relevant to the assessment of weight. So it's the increase in emissions, gone from 16 to plus 20. Secretary of State, this is the sentence, also the Secretary of State notes the resultant increase in the contribution of the proposed development to the power sector carbon budgets. So that's a reflection of one of Dr. Boswell's points. She's taken that into account as part of her judgment call as well. She agrees with the examining authority in giving more weight to the 2024 NPSs than a comparison of UK carbon budgets for the assessment of significance, but has taken this increase into account. Overall, she considers cumulative whole life GHG emissions are a significant adverse effect, carrying significant weight, negative weight in the planning balance. And so that's the conclusion. There are a number of different things there going to both significance and weight. And in my submission, as the judge found, that's a perfectly lawful conclusion to have been reached. It's explained. It is not expressly or impliedly an application of the IEMA criteria. It's inconsistent with an application of the IEMA criteria. And insofar as relevant to ground 2, it is also not simply saying national policy tells me it's significant and therefore I close my mind to all other factors.
Right.
I now am going to make submissions on the grounds of appeal. I think I can take these relatively briefly. I want to do it by reference to the judgment. So if we turn up the judgment, which is in your bundle, starting at page 77, the judge's analysis, so the conclusions start at paragraph 72 on page 94. There's one preliminary point raised by the appellant, which is as to the standard of review. I don't actually think, having heard her submissions yesterday, that there's much between us on the standard of review on appeal. I don't understand the appellant to be saying that this is not a review of the judge's decision. And I don't understand her to be saying that the question is not whether the judge had proper and legitimate basis to reach the findings that she did. So I think we're agreed on the test that's to be applied in this case.
Well, are we, I suppose the other way of asking the question or posing the question would be, are we looking at matters as it were with a blank sheet of paper or not?
I think we're both agreed that you're not. So on to ground 1.
Yeah.
Point 1 that the claimant makes is that the judge was wrong to find that the Secretary of State didn't use the IEMA guidance. You see the judge's conclusion at paragraph 73. She does not refer to the IEMA guidance in that paragraph, nor does she refer to the analysis which is set out in the guidance. She does refer to the NPS. And an agreement there that had she been relying on the IEMA guidance, she could reasonably be expected to have said so. In my submission, that is perfectly proper and legitimate conclusion to reach on the basis of all the material I've just shown you. In particular, the decision letter is very clear that the Secretary of State agreed with the examining's findings on significance, and we looked in detail at what those findings on significance were and the factors the XA took into account, which also did not involve the AIMA Chapter 6 criteria. The second point that the appellant makes is that the judge found that the examining authority had relied on the AIMA criteria.
Where is that again?
That is, I'm just looking for it. I've temporarily lost it. Paragraph 72. She says, although the IPs use the AIMA guidance, and this was relied upon by the examining authority if it's read sensibly in a whole.
But what she doesn't do is to say in what respects.
Exactly. And you've seen, as I showed you today, in what respects the examining authority did.
You have to drill down a little bit more.
You do. So those references to AIMA in the examining authority's report, upon which the examining authority relied, arose in the context of specific issues, in the context of Chapter 5, and the question, what do you assess?
And, forgive me, but we did hear from the appellant yesterday that whatever the judge said about this, the appellant accepts that the examining authority did not apply page
116.
116.
My second point, which I made yesterday on this, is that even if the examining authority had relied on AIMA for the significance assessment, you've seen a lot of references from AIMA guidance which says that all emissions have the potential to be significant. It recognises that contextualising emissions is a matter of professional judgment and that one is entitled to look at all sorts of factors. So you're not fixed with the criteria. And third, my third point, to finish this off, which you've already heard from me, is that the examining authority was not picking between rival applications to the criteria, because Dr. Boswell's submissions on that came after. And it's very clear the examining authority reached its judgment on a different basis. The third point the appellant makes is that there are numerous references to the AIMA guidance in the decision letter. We've looked at those, and you have my submission that they arise in a specific context.
I thought a moment ago, sorry, just going back to the previous submission, you were saying that even in relation to the post-panel report submissions, Dr. Boswell's material didn't involve an application of page 116.
Yes, so that's...
It involved a comparison with the carpet.
Yes, so I'm on what the examining authority had,
Yes.
which is it wasn't picking between rival contentions. But even the Secretary of State wasn't
Yeah,
picking.
but ultimately we have to look at it by the time the music stops in the decision letter.
Yes. And that's not the choice that the Secretary of State was making, wasn't between these two rival applications of 116. Even if it had been, Secretary of State doesn't, it's not litigation, the Secretary of State doesn't have to say you win, you lose. The Secretary of State's entitled to go
Well,
another
if the
way.
Secretary of State decides not to apply AIMA at all.
Which...
Well, one might ask, what's the point of adjudicating additionally on a difference of view on the application of page 116 if you're not going to base your decision on that?
Well, yes, the obligation in the Planning Act is to give reasons for your decision.
For the decision. Yeah.
And the obligation in the EIA is to give your reasoned conclusion. And that is what 4.58 of the DL is doing when read together with 4.58. When read together with...
I was carefully not saying anything.
aiming for me. When read together with the relevant conclusions of the examining authority's report. Point 4 is that the decision letter did not refer to any other method or criteria. The basic submission there is the Secretary of State didn't have to. It's a judgment. not required to have any specific criteria by law or by policy. The exercise that AIMA guidance encourages is contextualization. And there's no error, legal error, in looking at the factors that the Secretary of State looked at, which was, as the judge says, at paragraph 74, a clear, if perhaps a little simplistic, approach that it's a very large quantum of greenhouse gas emissions.
Yeah.
The claimant's fifth point is that...
We're still on ground one.
Still on ground one.
Yeah.
We're nearly finished.
No, I just wanted to be clear that we're still in that.
Yes, yeah. The appellant's fifth point, the appellant contended in his skeleton that EN1 was only referred to in the context of weight. I think that was part of a submission that, if not AIMA, then what? That seems to have evolved somewhat over the course of oral argument, now saying that if not AIMA, then, well, this is the alternative submission, if not AIMA, then you only relied on EN1, and that is unlawful. As to if not AIMA, then what? Again, read the decision letter. It's very clear what the factors were. And I'll deal with the unlawfulness point under ground 2. Going back to the judgment.
Can I just ask a question before you move on? If Dr. Boswell was not advancing a case based on page 116, ground 1, which claims that there was an illogicality, an inconsistency in the decision letter, that wasn't actually a point being raised before the Secretary of State. If you treat this as being significant in terms of page 116, it follows that it's incompatible with the trajectory towards net zero. That line of argument doesn't seem to have been deployed before.
No, the appellant's argument was it's not the best way to do it, and that it carries risks.
But what's now...
So what's now advanced is a different point, which is this logical flaw point.
I mean, it's fair to say one can have an illogicality point which arises when you see the decision letter.
Yes.
One shouldn't lose sight of that.
And that is, I mean, that point is also apparent when you step back again and look at what it is that this challenge is. There's a reasons challenge, not an irrationality challenge.
In practical terms, this tension point that's being raised, if it had been deployed, it might have affected the drafting of the decision letter, if it was necessary to do so. But, no.
Well, the decision letter, in my submission, actually does resolve the tension anyway, because
it avoids it, you say.
Well, it responds to it because 4.58 says, I think, Secretary of State, this does help with net zero. And you've got the reasons for that. It's not just a bare assertion. You've got the reasons for that earlier on in the decision letter. So even if it had been advanced, the decision letter actually does respond to it. And it's clear, applying the reason standard, what was decided and why.
You said helps the trajectory to net zero there, not merely supports it.
Yes, that's the language you used.
Yeah.
Would help deliver. So not just not inconsistent with, but actually positively.
And support can have two meanings, can't it?
Mm-hmm.
At least.
Finishing off on ground 1, there were some arguments advanced as to flaws in the judgment. They are directed at paragraph 75. The judge says if the claimant's right on the use of AIMA, then it'd be correct to say that DL 4.58 makes little sense. The submission is made that that's not the right way of looking at it. In my submission, it is, because what the exercise the judge is carrying out is what's a fair a benevolent reading of the decision letter, it is entirely legitimate to sense check that and say, well, if the appellant is right, is that actually a likely conclusion? Is that a conclusion that actually works? And the answer is no. The decision letter does make no sense if you import in a conclusion that the scheme is inconsistent with net zero, because it's all over the decision letter that it will help.
Right.
And that's a point made in paragraph 76 of the judgment, where the judge agrees with my learned friend Mr. Philpott that the construction and the exercise the appellant was carrying out willfully ignores what's said in national policy about helping.
Do you need the word willful?
Yes, so I agree with Mr. Philpott, the claim is willfully choosing
Well, I
to
know it's
ignore.
there, but does one need it? It doesn't make any difference if it's not
It doesn't,
willful.
there's not any, I'm not placing any emphasis on willful,
Well,
simply that
no.
it ignores, the analysis presented ignores the first half of the decision letter,
Yeah.
effectively.
One doesn't need the words as willfully choosing.
I don't place any reliance on
The
them.
question is, does it or doesn't it ignore in an entirely, if you like, morally neutral connotation? It's what the judge is saying is that the claimant's argument doesn't take into account.
Yes.
I mean, that's a more direct way.
Yes, and that's the substance of the point I'm advancing, which is that you've got to look at the decision letter as a whole, all of the reasons which are there and plain to be seen.
Yeah. I mean, we'll listen to the way in which Mr. Philpott puts it now in this court. But it strikes me at least that one can read 76 in that way.
So, in conclusion, on ground one, I think you've heard all of my points. The conclusion in the judgment is right. IEMA was not applied. It's very clear what the reasons were. And so no logical flaw arises.
Right.
Ground two then criticises the judge's conclusion that the Secretary of State was basing the assessment of significance on national policy and that was a lawful exercise. That's at paragraph 79 to 80 of the judgment. The point here is that if the Secretary of State didn't use IEMA, the Secretary of State only used national policy and that is unlawful. That evolved slightly yesterday to the statement in national policy, if it is prescribing that emissions are significant, is an irrelevant consideration. That's my understanding of how the submission is now advanced. The first question, therefore, is, well, what does 5.2.2 mean? We looked at this yesterday in some detail. If we go back to 5.2.2 at page 305 of the supplemental bundle.
Sorry, page again.
305.
Thank you.
It's not controversial that planning policy has to be interpreted in light of its context. The context here is that this is a national policy statement that is dealing with the dilemma of how do you achieve net zero whilst also achieving energy security. and an energy mix that enables you to have renewables but also backup in the event that those renewables are not operational. That policy balance is set out in this document. It was consulted on. It was itself subject to strategic environmental assessment. And it is dealing with major infrastructure, big things in simple terms. And so against that background, the first sentence of 5.2.2 is a value judgment that CO2 emissions are, it's a recognition that CO2 emissions are a significant adverse impact. That doesn't prescribe the outcome of any individual assessment. It doesn't say you must always, in EIA, conclude that they're a significant adverse effect. It is recognising, in effect, reality and setting out the government's value judgment on significance to be taken into account as part of the contextualisation exercise in any EIA reasoned conclusion. That is, in my submission, perfectly lawful, and was therefore a consideration that the Secretary of State, the examining authority, were entitled to draw on when looking at the question of significance.
Can I just be clear, what is it in 522 that can be taken into account in a reasoned conclusion?
The statement CO2 emissions are a significant adverse impact.
The first sentence?
Yeah, the first sentence. That can be taken into account. That's, as a matter of principle, there's nothing to prevent government setting out its stall on what it thinks is and isn't significant, given that it's a value judgment for the decision maker. As a matter of practice, IEMA also recognises that national policy is relevant when contextualising.
Yep.
And so there's nothing wrong with approaching it the way the Secretary of State did. But what it is not, it's not a deeming provision that prevents you or stops you from carrying out EIA. You still have to do that. And that's very clear from the rest of the paragraph, which refers to an ES on emissions, including an assessment of CO2 emissions. So the NPS itself expects an assessment to be carried out, but it's giving you the value judgment that the government thinks is appropriate.
But to put this into the context of the argument we were hearing yesterday, the appellant would ask, well, what's the missing ingredient for having a reasoned conclusion? And on the evidence presented in this case, it was a comparison with carbon budgets or the NDC. So that you're actually expressing your view about the effect on the environment. But doesn't the rest of 522 address that by saying that this type is relevant, that there's no need to make a comparison with carbon budgets? Isn't the rest of the paragraph relevant to a reasoned conclusion of that nature as well?
Yes, it is, because it's saying that there's no requirement to contextualise in this particular way.
Because of the mechanism which is envisaged, rightly or wrongly, and it's not a matter for the court to judge, the mechanism for dealing with this issue.
Yes, and that is the reasoned conclusion is then the decision maker grappling with that issue. So it looks at national policy and says it's significant, you don't have to assess it against carbon budgets, looking also at all of the environmental information that's been provided, where there is a comparison with carbon budgets, there's Dr. Boswell's comparison with fuel sector budgets, there's the IEMA guidance, all of these things are taken into account, and the reasoned conclusion is that set out in the decision letter, which is, it's a lot of carbon emissions.
I mean, a decision maker is entitled to have a policy. In this case, it's a policy which has been approved by Parliament.
Yes.
And has statutory force.
Yes.
It's not being suggested that this is a case of a closed mind.
No.
Simply by taking the policy into account.
Exactly, and it's the policy in addition to all of the other environmental information which the regulations require you to take into account, and they're totally compatible with one another. It doesn't say, don't take into account any other environmental information. The statutory process, the EIA process, is still working, and the two are consistent, and that's why the Finch point doesn't arise. This is not a Finch
Well,
case.
the Finch point, put simply, goes back to the application of Chapter 5 of IEMA.
Yes.
What do you take into account? What do you measure?
Yes. Not how do you carry out your value judgment. The next point, which is made in the judgment and which is criticised by the appellant, is that the judge was muddling the factors that go to significance and go to weight. In my submission, that is trying to set up bright line distinctions that don't exist as a matter of principle. We discussed that yesterday when looking at, do you need to reach a reasoned conclusion first and then integrate it? Or can you integrate it all in one go?
I was thinking overnight, I mean, it's a bit like the debate we've had in the past about how you apply something like section 38.6 and the tilted balance. You can do it separately, but so long as you take all the factors into account, sometimes it's permissible to do it all in one go.
Yes, and that's both EIA and planning decisions are, we have to remember, practical decisions with real life effects. They're trying to get to good decision making, and seeking to prescribe it into a series of steps might not be the best way of doing it. So why require...
It might depend on the nature of the subject matter.
Yes. But as a matter of principle, as the judge found, there's no reason why you can't use the same factors going to both significance and weight. In this case, they are the same factors, because it's a question of, well, how much carbon have you got? What does national policy say? It's very difficult to think in principle what a bright line distinction between a significance factor.
Well, you might be able to distinguish them, but the question is whether you have to.
Yes.
Is that right? I mean, in other words, you could go through the exercise, could you, of separately considering the question of significance and the question of weight. That's a legitimate thing to do, other things being equal, but you don't necessarily have to do it that way.
That's correct. And my point is the same things will probably pop up at both stages of the analysis, like the volume of carbon.
I mean, the debate about reasoned conclusion and integration, the EIA process facilitates decision making.
Yes. Yes, and there's all sorts of case law. You have blue.
I mean, the process ends up with a decision.
Yeah.
And that's when you integrate. But it's a seamless, may not always seem so, it's a seamless process intellectually. I'm really struggling to see why you should necessarily, as a matter of law, have separate reasoned conclusions before you go on to integrate.
That's part of the purpose of the EI regulations, is to integrate environmental decision-making into development consent decision-making.
Yeah.
Or town and country planning decision-making.
Yes.
In your understanding of ground 2, is it necessary that encapsulates means determines the outcome? I'm just not quite sure. With my lord, you've just been discussing whether or not they're relevant considerations at either point. And I thought at one point yesterday, that ground 2 was dependent upon an assertion that the judge was accepting that they prescribed the outcome, and you touched on that again today. If that's not what the case is, at the moment I'm having some difficulty, because I can't see any basis upon which things are irrelevant. And if encapsulate simply means are relevant considerations to be taken into account when carrying out those stages, at the moment I can't see the problem. Perhaps I really ought to ask the other side, but whether ground 2 is dependent upon prescribing the outcome. If that makes any sense at all.
It does. I don't think that was an alternative solution. So I think Ms. Dobson's point is that it would be wrong if my case had been it prescribes the outcome then that is unlawful. Mm-hmm. That is one of the points that she's making. But that's not my case.
That I can understand.
And that's not my case.
No.
We also have to bear in mind the West Berkshire decision in the Court of Appeal, where I was reminded that the policy doesn't have to explicitly allow for exceptions in order to be a lawful policy.
Yes.
It's intrinsic to a policy that it will be applied as policy, not as a rule.
Yes, exactly. It's not a, I have that
It's
written
not
down,
being
it's not a
suggested
statute.
here there's anything in the decision letter which fell into that trap.
That's right.
I mean, obviously, there are statutory parameters here in the Act, which stipulates how one is to approach a relevant policy.
Yes.
So that there's a separate statutory regime for major infrastructure of this kind.
Yes, but there is case law, and I have temporarily forgotten what it is.
Scarisbrick, I think.
Yes. That the same principles of policy interpretation apply to national policy
I
statements.
think I did say
Yes,
that.
Scarisbrick.
But it's a long time ago.
Yes. So, I think that gets me effectively to the end of ground 2. Very basically, as a matter of fact, the Secretary of State didn't just look at EN1, and you've seen that earlier today. And even if that is what the Secretary of State had done, then all of my submissions about why that's okay apply. Ground 3 then is that in circumstances where the Secretary of State wasn't applying the IMA criteria, the Secretary of State was obliged to give reasons for not doing so. You've heard my submissions on the actual factual context to the Secretary of State's decision and how this wasn't a case of picking between these two rival contentions. The standard of reasons is to identify what was decided and why. We are looking for real, not forensic doubt as to what was decided and why, and also whether there's doubt as to whether a legal error was reached. For all of the reasons I've already given you, it's very clear what the Secretary of State decided on significance and why the Secretary of State decided that, and that was not by reference to the IEMA criteria. No further reasons were required. There is only forensic doubt in this case. If there's even forensic doubt, I wouldn't accept there was forensic doubt, but certainly there is no doubt as to what was decided and why. And so with that, my lords, unless I can assist you further.
Thank you very much. Mr. Philpott.
Well, if I can just take the lectern from... May it please your Lordship, our position is closely aligned with that of the Secretary of State as first respondent, and I respectfully endorse and adopt the very thorough oral submissions that Ms. Grogan has made on behalf of the first respondent, and I don't propose to repeat them. So far as my oral submissions are concerned, unless the court will find it helpful, I don't intend to say anything more about ground 3. I can to rely on what I put in my skeleton argument on that point.
Right.
And so I'm going to deal with the following matters. I've got some submissions first on the appellant's approach to the Secretary of State's reasoning, then some further submissions on ground 1, and then some brief submissions on ground 2, but I'll be quite short on that.
Right.
But so far as the first heading is concerned, the appellant's approach to the Secretary of State's reasoning, my first submission concerns the familiar principle that when reading decision letters, the court must not only read them as a whole and in a straightforward manner, but also recognise they're addressed to parties who are well aware of the issues involved. Now, in a case such as this, which fell to be determined pursuant to the highly structured approach to decision-making under Section 104 of the Planning Act, by reference to the policies in the national policy statements, the parties can be assumed to be well aware of what those policies say. And in judging whether in this case the reasoning leaves room for any genuine as opposed to forensic doubt as to why the decision was made, say that policy context is important. And if I can just ask the court to take up the judgment, so this is in core bundle tab 4, and then turn to page 82.
Page 82.
Page 82.
Yeah.
And I'll try and deal with this briefly because you all should have seen this before. But the judge below provided a summary of the policy position in paragraphs 18 to 26. We provided a more comprehensive analysis in the skeleton. But even just taking this short version, it's plain that carbon capture and storage and gas-fired generation with carbon capture and storage is regarded in government policy as not just consistent with the trajectory for achieving net zero, but as a necessary element of the plans for achieving it. And one can pick that up even if one only looks at paragraph 21, which talks about the position in the most up-to-date version of the MPS. But then, of course, it goes on to deal from paragraphs 23 onwards with the non-planning policies, which make its role clear. And in particular, paragraph 26, the carbon budget delivery plan, table 5 of which deals with quantified proposals and policies, one can see over the page that it includes this particular scheme.
I mean, the carbon budget delivery plan, I think, was one of 2 documents issued in March, which followed the High Court decision in the Friends of the Earth case on the net zero strategy. So it was the government's response a year later to that litigation.
Indeed. So what that is,
hence the importance of its status.
Indeed, and it's illustrating the point which one already gets from the most recent version of the MPS, that the government has taken a view, a judgment, as to the role which this sort of development should play in national energy policy and in the energy mix, having regard to the need to meet the net zero trajectory. And the explanation in policy of the part to be played by projects such as this in delivering the government's plans for the transition to net zero is then reflected in what was said about need and benefits in both the examining authority's report and the decision letter. And what was then said, Ms. Grogan has explained how the documents are structured, about climate change and the fact that there would be significant adverse impact from the greenhouse gas emissions from this project must be read in the context of that policy, what it says about the need for and role of gas-fired generating capacity with CCS in the energy mix during the transition to net zero, and the conclusions reached by the examining authority and the Secretary of State about the project's compliance with the requirements of the relevant NPS policy. And I'm going to come back in due course to that question of compliance with policy, which is highly relevant to the appellant's contention under ground 1 that the Secretary of State was in fact reaching a judgment by reference to the Section 6 IEMA criteria. And as the judge said at paragraph 76 of the judgment, so this is on page 94, and it's the final sentence of paragraph 76. The basis of the Secretary of State's approach is clear, both from the policy documents and the examining authority's report and decision letter in this case. And that formulation reflects the need to understand the decision documents in the context of the policy that they were applying. And we say the judge was plainly right, and at the very least entitled to find that the Secretary of State's approach is clear when you look at those things together. Now, Miss Grogan took your lordships to what the second edition of the IEMA guidance says about the relevance of national policy in contextualisation. And there are two further references I want to go to just to develop that point a little further. So can I ask your lordship to take up the supplementary bundle and turn please to tab 5, where we have the second edition of the IEMA guidance. And within that, can we go please to page 119?
But can you give me the reference again?
It's tab 5 of the supplementary bundle, and it's page 119. And we looked at the final paragraph in the right-hand column, the first part of that paragraph, yesterday I think it was. And I want to draw attention to the final sentence of that paragraph, which begins Table 1. Table 1 sets out further sources of contextual information against which the greenhouse gas emissions and reduction actions of the project can be evaluated. And then one goes to page 120 and Table 1, which is entitled Sources of Contextual Information Against Which Projects Can Be Evaluated. And if one then, there are shaded and plain entries, and it's the third shaded entry, existing and emerging national and local policy or regulation. And if one looks to the second column, the advantages of this as a source of contextual information, and the final bullet point, policy should be compatible with the UK's national greenhouse gas commitments and actions to achieve those. So what that is...
Yeah, I looked at this yesterday. There's also, I don't know how far this takes you, because there's the limitations column alongside it.
Well, there can, but what it deals with, my lord, is this. It's plain, not only that policy is relevant for the purposes of contextualisation, but also when one is looking at statements in policy about significance of effects, one needs to understand those in their full context. And as has been made plain here, the context is a policy which expresses the government's view about what developments would be consistent with the trajectory.
Underpinning the policy is
Exactly.
an understanding, rightly or wrongly, as the way they see it, as to how the trajectory will be achieved.
Indeed. And so that again has significance when it comes to the suggestion implicit in ground 1 that what the Secretary of State was actually doing when looking at the greenhouse gas emissions here was reaching a conclusion by reference to IEMA that this was in some way inconsistent with the trajectory, that there was some therefore tension in the reasoning. Because when you look at what the policy is seeking to do, and the statement in the policy to which the Secretary of State had regard in reaching conclusions on greenhouse gas emissions and look at it in context, not just of what the policy says, but of what the decision says about how this fits into the trajectory, it is highly unlikely that the Secretary of State was effectively concluding that the policy was wrong, that this was not compatible with the trajectory. There was nothing inconsistent with a recognition of significant adverse impacts in terms of greenhouse gas emissions from this type of development with the rest of the policy and the rest of the decision, which recognises the role that this sort of development has in meeting the trajectory.
Well, just pausing, to what degree would it have been open to the Secretary of State even to do that, given the statutory scheme?
Well, indeed. It would amount to a disagreement with the merits of policy.
Which would take him directly contrary to one of the provisions in the Act.
Indeed. And it is, my Lord, this comes on to my second point, and it touches on the point that was being raised earlier in the context of the way that the claimant, now appellant, deals with policy. And I should say at the start, for my part, whether it's a question of willful choosing or not, doesn't matter. What matters is the substance of it. And if one goes, please, it's still in the supplementary bundle, to tab 9. And these are the appellant's post-examination representations. We looked at page 220 earlier, but I'd like to go back there, please, where this is the IEMA contextualisation.
Sorry, the page again?
220.
Thank you.
Page 117, where the appellant notes and emphasises the benefits of looking at policy for the purpose of contextualisation, and indeed picks up in the final part of that paragraph, the passage to which I referred earlier. But then in terms of the appellant's choice of policy, there is no consideration of the national policy statements that had to be applied in this case. So I draw attention to that as an example of a wider point, which we've made before. We made it in the pleadings, we've made it in the skeleton argument, and indeed it's reflected in the oral submissions, that there is no and has never been any proper attempt by the claimant, now appellant, to grapple with what the policy says and how that deals with and how that affects the two key planks of its case, namely that the claim that the Secretary of State based on a judgment about significance of greenhouse gas impacts on an application of the IEMA Section 6 criteria, or the complaints made about the adequacy of the reasoning. Now, my Lord, if I can then turn to ground one in that context, and the issue of whether the Secretary of State reached a decision using the criteria in Section 6 of the IEMA guidance. I won't repeat the submissions you've heard. I want to focus on one particular element, which is about the conclusions reached as to compliance with policy on mitigating greenhouse gas emissions. But just standing back from that, there is an air of, I say, unreality about the appellant's suggested reading of the decision letter. And it's in this context, I'd ask, please, first of all, Your Lordships, just to take up the IEMA guidance, Section 6 again. I know we've looked at it, but just to remind Your Lordships of the text in page 117, the examples of the significance criteria which are given in box 3 on page 117 of the supplementary bundle. And remembering, as the introductory text explains, that significant applying these criteria would be either major or moderate adverse, major being the greenhouse gas impacts of the project, are not mitigated or only compliant with due minimum standards set through regulation, and don't provide further reductions required by existing national policy for projects of this type, and then not make a meaningful contribution to the UK's trajectory towards net zero, and then moderate, partially mitigated impact, partially meet applicable existing and emerging policy requirements, don't fully contribute to decarbonisation in line with national policy goals for projects of this type. So keep those words, if your Lordships would, in mind. We've seen already government policy about how carbon capture and storage is critical to achieving net zero targets, and the conclusions reached by the examining authority and the Secretary of State about the need for and benefits of this project. But it's also important in the context of what the IEMA guidance says to note the conclusions reached by the examining authority and the Secretary of State about the compliance of this project with the policy in the NPS on mitigating greenhouse gas emissions, and indeed for this project going further than the requirements set by policy, because this is a full chain carbon capture and storage project rather than just being carbon capture ready. So I just want to provide some references, if I can, to those parts of the decision documents.
Yeah.
And if one can go, please, first.
I mean, ready involves that, for example, a site is allocated for the provision of the infrastructure if and when the technology comes along.
Indeed.
That's why carbon CCR was referred to in the 2011 document. But I think what you're submitting is we've now got to the stage where the technology is there.
Well, it's not just a matter of technology, Lord, it's also about the ability to take the carbon when it's captured at a particular power station and transport it to a store.
Yes.
And the proposal here is described as full chain because it includes both the emitter and, through other consents,
the storage.
The storage. So it allows the full chain of the carbon capture storage.
I was just distinguishing it from CCR.
Indeed.
CCR was basically a hole.
It's a project which...
There's space for something to come along.
Yes, as and when the opportunity arises.
Yeah.
And if one starts with the examining authority's report, which deals with this, if one goes, this is in the supplementary bundle behind tab 8, and go to page 174, paragraph 5.2.105, where the examining authority noted that in providing CCS, the proposed development is in accordance with section 3.6 of EN1 and in line with government's wider policy statement on energy and climate change. And then it carries on, proposed development would see the provision of additional low carbon mid-merit plant equipped with CCS generation being deployed on commercial scale, and then deals with the range of legislation and policy it's dealt with in paragraph 3.6. That's also reflected then in paragraph 5.2.125 on the facing page. But if one goes back to the scope of the proposed development on page 174, 52109, applicants have demonstrated to our satisfaction that they've met the criteria in EN1 to assess whether a project is carbon capture ready. And then if one goes on to 175 to paragraph 5.128, the combination of R31, that's a requirement, 31 that's imposed like a condition on the development consent order, and the environmental permits would require the operation of the CCGT and the capture plant to achieve a specified capture rate, and would provide appropriate controls to ensure that the normal commercial operation of the CCGT would involve the capture of CO2 to the standard of best available technique and transportation for offshore storage. And then if one goes to page 178, paragraphs 5.3.13 and 5.3.14 deal with policy on operational emissions, and we've looked at what those are. I don't need to ask you to read those. But then on to page 183, please, paragraph 5.3.49. We are satisfied from the information provided in chapter 21 of the environmental statement that the applicants have taken all reasonable steps to reduce the greenhouse gas emissions during construction, operation and decommissioning as required in EN1. And then if one goes through to the page 188 conclusion, this is in the planning balance section, section 7, paragraph 7.3.12. There is nothing to indicate the application should be decided other than in accordance with national policy, and we find the proposed development would be in accordance with the relevant NPSs. So that's the examining authority's approach to compliance with policy requirements on greenhouse gas emissions. And then if I can ask your lordships to go to the core bundle to look at the decision letter.
Can we put that away now?
Indeed, that can be put to one side. So the decision letter, which is behind tab 27 in the core bundle. And if we can go first, please, in that document to page 423.
Yeah.
So 435 of the decision letter picks up 4 lines down. The examining authority had noted that EN1 requires all commercial scale combustion power stations must be constructed carbon capture ready. And then if one goes back, please, to page 417, so that's the policy requirement. Paragraph 411, and we're about a third of the way down, sentence. The examining authority considered that by providing CCS, the proposed development would be in line with government's wider policy statements, and then identifies those matters. And then further down, in the final third of the paragraph, the Secretary of State notes that designated 2024 EN1 further strengthens support for the proposed development by making nationally significant low-carbon infrastructure, including natural gas-fired electricity generation, which is carbon capture ready, a critical national priority. The Secretary of State also acknowledges that the full chain CCUS nature of the proposed development elevates it considerably above other CCR projects, as it will be required to capture a minimum of 90% of carbon when operating at full load throughout its operation, and will seek to achieve a capture rate of at least 95%. And then
are there controls on the development that limit it in that way?
yeah, so this is the combination of the controls on the face of the development consent order, which require it to be designed to achieve the requisite level of capture, requirements which ensure that it must operate with the rest of the infrastructure that's required to transport and then store the carbon, and then the environmental permit, which was referred to by the examining authority, which also regulates capture rate. So all of those matters secured, and then page 424, paragraph 437, the final 3 sentences, picking up the conclusion of the examining authority we looked at a moment ago. that they were satisfied the applicants had taken all reasonable steps to reduce greenhouse gas emissions during all stages. There's no indication by the Secretary of State of any disagreement with those conclusions. And therefore...
I'm probably being very slow, but just to knock it on the head. You're taking us to these paragraphs because singly and cumulatively they say this is in accordance with the overall strategy.
Indeed, it is. Okay. It's not just in accordance with the overall strategy, but it's in accordance with the detailed provisions of policy as to the mitigation of greenhouse gas emissions, going well beyond what's required by regulation, and in some cases going beyond what the policy requires, which in this case is being carbon capture ready. And the Secretary of State acknowledges this goes beyond that. So the submission that's being made to you by the appellant, which is that you should read the decision letter as concluding that the Secretary of State was applying those criteria and finding that this was significant adverse by applying those criteria, is unreal. It's totally irreconcilable with the careful and explicit consideration of greenhouse gas emissions that was undertaken in the decision documents in accordance with policy.
But picking up the language of the IEMA guidance, what you're focusing on is trying to demolish the suggestion that because IEMA was being used as a shorthand, the finding is that it does not support the net zero strategy.
Well, my Lord, my point is this, that when you look at the way that the decision was reasoned, it's quite clear, we say, for the reasons that Ms. Grogan has explained, that it is not purporting to or actually applying the criteria in IEMA. My point is that if you then ask yourself whether such a construction of the decision letter, despite the fact that it's not appearing to do that, would make any sense when one looks at the rest of the decision letter, it plainly would not just because of the reasons that are given, but because it would be flatly contradictory to the conclusions that are reached by reference to the points that are made by IEMA in those criteria. It is the point the judge made that this is effectively trying to create an inconsistency where there isn't one if you just look at the decision letter on its face, but in the light of policy.
Thank
you. These findings of consistency with national policy are inconsistent with the suggestion that the decision maker was treating this as a significant adverse effect in the sense used by IEMA.
Indeed.
In a nutshell.
Yeah, that's the point. And I don't need to repeat the analysis of how the decision was actually reached, because that's been very clearly
explained. That's one reason why I drew attention to box 3 yesterday, where it tries to be a little bit more sophisticated than page 116 by saying we actually live in a policy world.
Indeed.
And there are degrees of compliance with policy.
Quite. And that's, I say, why the importance of those conclusions about policy compliance on greenhouse gas emissions just make it totally unreal to invite the court to say that that's what the decision maker was doing. And thus there is no inconsistency, and ground 1 just falls away. So, my Lord, unless there's anything else on ground 1, that was all I proposed to say on it. And then
nothing else.
I'm grateful, my Lord. And then I can deal briefly with ground 2, because the argument that is expressed in the appellant's skeleton argument and orally, which is about whether policy can dictate the outcome of an EIA, is both a mischaracterisation of the judge's findings and of the way the issue was addressed in the decision documents. Well, there's no finding by the judge that planning policy dictated the outcome of the EIA. And that's unsurprising because neither respondent had argued that it did, and neither the examining authority's report or the decision letter suggested as much. But what the decision documents evidently did do is consider that what the government had said about significance in policy was a material consideration when exercising a judgment about the issue of significance, or, in the language of IEMA, contextualising the quantitative assessment. And we say that, therefore, the only real legal issue that arises is whether the statement in policy to which the Secretary of State referred is legally capable of being a material consideration when forming a judgment whether the greenhouse gas emissions here were significant. Now, that, if I may say so, is a relatively low bar. We say that there is no authority relied on to say that such a judgment expressed in policy must, as a matter of principle, be legally irrelevant to a subsequent judgment on an individual development proposal, nor is there any obvious logic that would support such an outcome. That the appellant's reliance on Finch goes nowhere, because the point in Finch is as to whether policy is relevant to the scope of the assessment, i.e. what's an effect of the project. And it said, well, that must mean it's also irrelevant to the judgment on significance. But there's no legal or logical basis to justify that leap in the reasoning. Because as the Supreme Court made clear, the point it was dealing with was a matter of statutory interpretation rather than judgment. And that's paragraph 151 of the judgment. But here, we're dealing with a matter of judgment, as Finch says at paragraph 58. So it's just not an authority that assists the appellant in any way. And nor did the judge suggest, as the appellant suggests in its skeleton argument at paragraph 62, that the assessment of significance is legally indistinct from the assessment of weight to impact. And if I can ask your lordships just to look at what the judge did say, so this is back in the core bundle, tab 4, paragraph 80, on page 95, one can see from the first sentence of paragraph 80 that what the judge was rejecting was the suggestion that there should be a bright line distinction between matters that go to EIA and those that go to determination, and was making the point correctly, we say, that's both unjustified and unhelpful. So it's not suggesting that there's no legal distinction between them, it's just that the matters that are relevant may be relevant, as Ms. Craven has made clear, to both exercises. And it's also notable, in terms of understanding, well, what's the practical purpose of this part of the appellant's case, that the appellant doesn't disagree with the Secretary of State's substantive conclusion that the greenhouse gas impact of this project was significant. There's no disagreement with that. Nor could the appellant suggest that it's in any way inconsistent with the judgment that was made in the National Policy Statement to which the Secretary of State refers when reaching it. Nor does the appellant say the judgment expressed in policy is wrong, or that the weight that's given to this impact in the decision letter was wrong. And the only apparent motivation for complaining about the Secretary of State's reasoning on this issue is the very fact that the likelihood of such significant impacts is anticipated by national policy and does not mean that the development is inconsistent with policy or otherwise point to the refusal of consent. And again, therefore, we say the true focus of the appellant's complaint is the approach that national policy takes towards the role of infrastructure such as this and how emissions will be addressed in decision making and as part of the overall strategy for achieving net zero. And that's not a matter that is a suitable one for review. So, my lord, that's all I was going to say on ground 2. And indeed, for those reasons, we say the appeal should be dismissed, unless I can assist further.
Question.
Yes, my Lord, Lord Justice Holgate has a question.
If we go back to the judge's judgment, full bundle, page 84, you took us to the carbon budget delivery plan.
184.
Page 84,
80,
sorry,
yeah.
paragraph 26. And there's an extract from the plan which deals with power generation CCSU. And it's part of a table, which is, this is item 25. So I've just been trying to see where we find that in the bundle. And I think it's tab 19 of the supplemental bundle. And this is a statutory document. This is under the Climate Change Act 2008, section 14, presented to Parliament. So this is the Secretary of State's statement, if I paraphrase, as to how he will discharge his section 1 obligation to achieve net zero by 2050. And this bit, it appears on page 338 as part of a table, and then the item 25. I hope I've followed so far.
In my version, it's 334.
Four. Sorry, better still.
Yes.
334. And then I noticed at the top, it says sector policy name, average annual savings, and so on, in million tonnes of carbon dioxide. And timescale. I noticed that for this item, and indeed most of the items, there are no such figures. But if you go back to the beginning of the table, table 5, I think it's called, there is an explanation on page 329. Item 1, power. There you see some savings figures running along the top, and it explains why you can't disaggregate those figures for the power sector. But the legal significance, you see the table is marked quantified proposals and policies. The legal significance of this is that the High Court decision in Friends of the Earth said that the Secretary of State in the net zero strategy had acted unlawfully by not putting forward, where he could, quantification of the contributions that his policies were going to make. And this is the response to that. And there are other policies which presumably fall outside this table which are not quantified at all. That's how the strategy was drawn up. But this is all referable to the net zero target in the 2008 Act.
Yes.
This is an explanation of the trajectory, as I
Indeed.
understand it.
Yes, and the particular account taken of this project as part of that. And so, it goes to the question of the realism of the
I
suggestion.
mean, it appears in the judgment without any explanation.
Yes.
I'm just trying to understand what this paragraph is doing. But, just to complete the story, there was a second judicial review in front of Mr. Justice Sheldon. I don't know if it went any further to the Court of Appeal, but he was unhappy with aspects of the carbon budget plan, as I recollect. And I don't know whether he was unhappy with what the judge has quoted at paragraph 25, from 25.
I can assist with that.
Just want to tread carefully, that's all.
My Lord, Mr. Dobson was in that case, so can correct me if I'm wrong.
Yeah.
Mr. Justice Sheldon's judgment held that the Secretary of State had not lawfully dealt with delivery risk.
Oh, that was it, yes. So insofar as I criticise the net zero strategy for failing to deal with the quantification, how you built up the trajectory to not net zero by the policies that the government had chosen, that isn't the subject of the second JR. It's delivery risk instead.
That is correct. So having said there are material considerations which included delivery risk, the
Yes.
Secretary of State went away and produced this carbon budget delivery plan, which did address delivery risk, but not lawfully, as was held by Mr. Justice Sheldon.
Do you have the reference to that judgment?
Not at my fingertips.
No doubt we can find it.
I'm sure we can find it.
But it's
before
not the subject of an appeal, is it? Or
It is not. There is a new plan
yeah.
that is
And,
in the
and
works.
just whilst we're on the bundle, I mean, that's tab 19. The other document that came out in March, we have at tab 2023, we have at tab 18. And we've got extracts there, which is talking about electricity generation, unabated gas, CCSU. But that was published at the same time.
Yes.
My last question is, I don't think the examining authority referred to these 2023 documents. I may have missed that. I don't think they referred to the carbon budget.
I don't think that had
Yeah, but
had a date.
did the decision letter do that?
So, question one's
Or
about the examining.
is this just all very interesting but didn't find its way in the decision letter?
I'm just checking the chronology. The examining authority reported.
Maybe it is there and I've missed it.
So the examining authority reported to the Secretary of State on the 10th of February 2023. So that's before
Just before these documents came out.
what was called the March moment.
Yeah.
And these documents came out. And then the decision letter
16th of February
Does-
24.
refer to the updated position. I now need to find it.
Maybe we can come back.
I think I'll hunt for it while Ms. Dibson is making her submissions. For the reference for the Friends of the Earth number 2, it's 2024 EWHC 995 admin.
It doesn't appear to be referred to in paragraph 1.4, does it? If that's where one would expect to find it, I'm not sure if it is.
These decision letters do tend to refer to the Climate Change Act and where we are. Well, I'll have a look.
I had a look at section 4, legal and policy context, starting at page 414.
Yeah.
I couldn't, on a quick read through, I couldn't find it.
No, that's where I was looking as well.
I'm sorry.
Let me have a hunt and we'll let you know. I thought I had seen reference to the Friends of the Earth.
I thought I'd seen it somewhere, but I can't nail it down.
Well, if you go to page 493, about nearly just below the first hole punch, PUB powering up Britain, must be a reference to the March 2023 document, I think.
And likewise at page 491, you've got CBBP, the other March document.
Yeah.
Yes.
So it looks as if they were
In there somewhere.
taken into account.
Yes, paragraph 8.8 on page 485. Secretary of State has considered the UK 6th carbon budget requires. And there's a reference there to the Climate Change Act.
Yeah, we'd need to search the acronym PUB, I think, for that one.
Is that the powering up?
Yeah.
Yes. And 4.45. Which is on page 426. That's referring to powering up Britain.
That's the consult force, yes.
And the bottom of 446. Another reference there to powering up Britain.
Sorry, which paragraph?
4.46.
Yeah. Oh yes, PUB is referred to at the end of that paragraph.
Yes. And the reference, we took you to the references in Dr. Boswell's post-examination submission, where he's referring to the power sector contribution. That's to that row in the CBDP.
Right, thank you. Mr. Dobson, your reply.
My Lords, Mr. Shattuck has just sent a copy of the reported case in Friends of the Earth and Secretary of State for Energy Security Net Zero to the Clerk of Lord Justice Holgate. So that can be shared if it's
Thank you.
of assistance. My reply is going to focus on ground 2, but before I turn to that, just 2 brief points on ground 1. The first is something that has come up in submissions this morning, and that is the suggestion that the appellant did not rely on the IEMA criteria set out at page 116 of the second, that's the bundle reference, of the second version of the IEMA guidance in his September submission. And if I could just invite your Lordships to turn up briefly, page 224 of the supplementary bundle.
224.
224, this is the 6th of September submission from the appellant, where he sets out his route to the conclusion that greenhouse gas emissions will have a significant adverse impact. And he begins that at paragraph 145 with a reference to, and this is the final sentence of that paragraph, the table provided by the applicant in Rep 6123, table 3.5. If your Lordships then turn to page 152, so that Rep 6 references to the revised environmental statement, and page 152 of the bundle within the revised environmental statement sets out at table 3.5 the IEMA criteria.
So can you give the page reference again?
Yes, it's page 152
Thank you.
of the supplementary bundle. Sets out the significance criteria. And so when the appellant is saying in this part of his 6th of September submission that he concludes that the greenhouse gas emissions have a significant adverse impact for the purposes of the EIA regulations, he is referring to and applying the meaning given to that term in the second version of the IEMA guidance, and does so by reference to the revised environmental statement. And the second point on ground 1 is a minor point, but just on something my Lord Justice Holgate said, that I'd accepted yesterday the examining authority did not apply section 6 of the IEMA criteria, or page 116 as it is in the supplementary bundle. I accepted that there's no reference to those criteria in the examining authority's report, but our case is set out as
I think I asked you whether we could see them apply
Yes.
those criteria.
Yes, but we'd say
You
that
have your answer.
our submission, I think, is well understood by the court. We said read in the context of the submissions put forward by the parties.
Yeah.
It was. So on ground 2, in this reply, I'll seek to distill the key issues which the court will have to grapple with if the court is not with me on ground 1, that the Secretary of State relied on the IEMA guidance in reaching his conclusion that the greenhouse gas emissions were a significant adverse effect. So this is a world where the IEMA guidance and significance criteria are not in play. So the first issue is, what does the obligation under Regulation 21(1)(b) of the IA regulations to provide a reasoned conclusion require? What does it entail? And if I can invite your Lordships to turn up Regulation 21 of the IA regulations, it's Authorities Bundle, tab 2, page 24. And we can see from Regulation 21(1)(b), the obligation is to provide for the Secretary of State to reach a reasoned conclusion on the significant effects of the proposed development on the environment, taking into account examination of the environmental information. When the provision was discussed with my learned friend Miss Grogan yesterday, my Lord Justice Lindblom observed that the ON is doing important work. There are in fact 2 ONs, both material to what the provision requires. The first ON, that's reach a reasoned conclusion on the significant effects, makes clear that it's not just about identifying or stating that there are effects which are significant, i.e. that there are effects which cross the threshold so as to require assessment for EIA purposes. It's saying that it's not just necessary to assess what the significant effects are, but how significant they are. And just to repeat that effects are significant does not do that. And the second ON makes clear that the conclusion must assess the impact of the significant effects on the environment. And this requirement has to be read with the obligation under Regulation 5.2, which is backwards in the bundle at page 20, which says what the EIA process, which encapsulates the reasoned conclusion, must do. It must identify, describe and assess in an appropriate manner, in light of each individual case, the direct and indirect significant effects of the proposed development on the aspects of the environment listed there, which include climate. So it also requires an assessment of the impact on the environment.
Can you just give me the reference again, please?
Yes, it's page 20 of the authorities bundle.
Yeah.
Paragraph.
Regulation 252.
Yeah, I was going to ask you about that. Because going back, and we've got to read this all together.
Yes.
If you go back to Regulation 21(1)(b), it's imposing an obligation to reach a reasoned conclusion on.
Yes.
And it's telling you only need to reach reasoned conclusions on what qualifies as a significant effect. You don't have to reach a reasoned conclusion on insignificant effects.
Yeah.
So that ties in with what you've just taken us to in Regulation 5. It's telling us that the obligation is engaged in relation to matters which meet the threshold.
Yes.
Then, not surprisingly, given the nature of this provision, it's not telling the decision maker how to go about reaching reasoned conclusions.
It's, well, save that it has to take into account the environmental information, but no.
Yes,
but it is,
of course. Yes, absolutely.
But it does require more than simply saying an effect, we've identified this effect is significant.
But it wouldn't be enough just to say, here's the list of threshold effects.
And that's exactly where my submission is going. And just for completeness in terms of what has to the guidance it does, or what we can tell from the regulations about how that conclusion is reached. The point of the regulation, the environmental statement, which must be produced under Regulation 14, is to assist. It all leads to the reasoned conclusion that the Secretary of State must reach. And at Regulation 14(3)(b), so that's on page 23 of the bundle, we see that it must include the information reasonably required for reaching a reasoned conclusion on the significant effects of the development on the environment, taking into account current knowledge and methods of assessment. So it's envisaging that there will be material included in the environmental statement that's going to be necessary, material that goes to knowledge and methods of assessment of impacts on the environment that will be material to that conclusion. So drawing those threads together, the reasoned conclusion must identify not only whether an effect is significant, but also how significant it is and how it will affect the environment, what impact it will have on the environment. Before turning to what I'll say is the second question the court must grapple with, there was some discussion yesterday and this morning as to whether or not the process set out at Regulation 21, in particular the obligation to reach a reasoned conclusion and then the obligation to integrate that into the decision, are necessarily distinct stages in the process. I should say we've looked at this overnight and haven't been able to find a reported case that looks at this question. But in my submission they are, and this is reinforced by the fact that the regulations contain the separate obligation under Regulation 30, which is at tab 26 of the bundle, and subparagraph 2b, little Roman numeral 1 double A.
Sorry, you've lost me.
So it's page 26
26 of the bundle.
of the authorities bundle.
Right.
Regulation 32B, Roman numeral 1 double A.
2B
1AA.
1AA.
This is the obligation on the Secretary of State, having reached a reasoned conclusion, to set out specifically that reasoned conclusion in the decision notice. And it must set out the reasoned conclusion of the Secretary of State on the significant effects of the development on the environment, taking into account the results of the examination.
It's the same language again, isn't it? It's reasoned conclusion on the significant effect.
It
It's
is.
what he's supposed to have done under 21(1)(b.
Yes, and my
And then
submission,
that should be communicated.
it has to be communicated, but that,
It doesn't shed any more light on what a reasoned conclusion is.
no, it's to go to the point about this being a distinct part of the process, that at the very least has to be reported on as a distinct part of that process, separate from the conclusion that's reached when it's integrated into the decision. And this obligation is part of the
Well, the reason why
transparency
it's got to
function.
be integrated is because the overall decision on development consent won't be just to be based on environmental matters.
Yes, of course, this is one ingredient, but this regulation has the effect of separating out that ingredient, so it's a standalone part of the path to
Yes,
that
but
decision.
you would expect all the main issues, whether they be economic, planning, environmental, whatever, transport, each to be the subject of reasoned conclusions.
Yes, this is
It's not really saying very much.
no, but it's part of that transparency function that even after the decision is taken, including, and here it only arises if it's to grant consent, that we know what the environmental impact will be.
Could you just help us by locating this point in your skeleton argument for us?
About,
The point you're now developing.
I mean, this is, well, it goes to what, so it goes to our ground 2.
Yes, I'm looking at ground 2, which begins on page 23 of the core bundle. So which part of your case is there set out are we now dealing with?
So, well, it's not addressed in terms here. That actually comes under ground 3.
Was it addressed in the court below?
The argument is that if there isn't a, if you're not relying on IEMA to conclude significance, what are you relying on? What is the reasoned conclusion? If it's, and we say EM1 doesn't give the answer to this, so you haven't reached a reasoned conclusion.
No,
and I'll
but
find, yes,
I appreciate what you're arguing now, and that's why I'm asking you where we find what you're arguing now
So,
in your skeleton.
in our skeleton, it's paragraph 69 where we say
Right.
that if we don't know what the base, if it's not IEMA and we're not told what the basis is for the conclusion of significance, then there's not a reasoned conclusion for the purposes of Regulation 21.
Let us just read 69 then.
That's under ground 3. That's the reasons.
Yeah,
So, but this is, you're now tying this point to ground 2, as I understood.
yes, and that's, sorry,
So are we actually in ground 2 or ground 3?
well, they go together because it's all to do with the point of if you do not, if we're not in the world where reliance was placed by the Secretary of State on the IEMA guidance, then what did the Secretary of State rely upon for...
I was beginning to think that this case really turns on one, possibly 2 points. I mean, as you said at one stage, I think yesterday, I hope I have this right, the reason conclusion argument is all about, it is almost synonymous with the duty to give reasons.
Yes.
And it just happens, we just happen to be talking about an environmental effect as opposed to some other relevant planning consideration. And the way you put it is, see if I've got this, is to say when we're dealing with these significant environmental effects, particularly the carbon emissions, the obligation is only discharged if you say how significant it is and you put it into a context.
Yes, and
as my Lord explored with you yesterday, you can't say what the effect is on the climate, but we have intervening or lesser expressions, such as carbon budgets and trajectories and so on. But that's what the argument boils down to.
That's what it boils down to, and the way the grounds fit together, which I thought to give the overview of in my opening, is we'd understood the Secretary of State to reach this reasoned conclusion based on IEMA guidance, because that's the way it had been put by the parties and is the way it's generally approached. But if not IEMA, so we lose on ground 1, ground 2, the reliance is placed on emissions and EN1, and our case on ground 2 is, well, EN1 doesn't add anything, so it doesn't do enough to reach a reasoned conclusion. And ground 3, if you're departing from IEMA, you have to say so and make clear what you're relying on in the alternative. That's the reasoned conclusion obligation. So that's how they fit together. I was addressing the court
I'm just rereading what you said about ground 2 in your skills management.
Focuses, the ground 2 focuses on why EN1 doesn't address the question of significance for the purposes of the IA regulations.
I mean, I think at 62 you refer to regulation 21, don't you?
Yes.
Is that so? Do these submissions you're now making go to that point, or not?
That's going to the point that EN1, why EN1 can't be the basis for a reasoned conclusion.
Yeah, that's what I understood. That seemed to be ground 2 of your appeal, which doesn't seem to be quite the same point as is now being.
Well, as it goes together, we say if EN1 doesn't address.
I mean, it may. I don't know whether it belongs properly in ground 2 or ground 3. I mean, you've certainly developed submissions about regulation 21 in 68 and 69.
And it's to fill the gap. We say if EN1, so if IEMA is not there, that's ground 1. If we're into ground 2, if we're right that on ground 2, EN1 either doesn't assist either because it's not a deeming provision or because it says no more than an effect is significant, i.e. the threshold question, not the how significant, not the impact, then what is there? And that's the gap in the reasoning, which is required for the reasoned conclusion. I was developing the points that I say the court will have to consider if we're in the territory where IEMA isn't relied upon to explain the conclusion significant adverse. And the second point, which needs to be considered, is whether it's sufficient to say impacts are significant adverse to answer that question. It's a term, I think there was some agreement about this yesterday, significant is a term with different meanings. And there are spectrums of degrees of significance. And if it's right that it's not enough for the purposes of Regulation 21 to simply identify what the significant effects for the purposes of the IA regulations are, it's necessary to assess how significant they are. It would not discharge the obligation under Regulation 21 to simply state that an effect is significant without doing more. Ms. Grogan said it would be not necessary to categorise the effect, and if what's meant by that is it's not necessary to ascribe particular labels or refer to a benchmark, then we agree that obligation doesn't come from the regulations. But to answer that question of how significant, you need to do more than say simply it is significant. And that could be done in a number of ways. The parties relied on the IEMA guidance as to how to contextualise. It could draw on scientific literature about the nature of impacts on the environment. I'll just give a reference to this rather than taking your lordships to the document, but in the 9th of June 2022 submissions from the appellant, that's page 126.
126.
Sorry, 127 of the supplementary bundle, paragraph 6. the appellant had put before the Secretary of State information about the particular impact of methane as a category of greenhouse gas emissions, explaining that the atmospheric methane is much more potent than carbon dioxide as a climate-disrupting gas. So that's an example of the sort of information that could be relied upon to look at impact. GOESA, the case that was looked at yesterday, makes the point that the decision maker can identify different benchmarks he considers necessary. Our point is that you have to do something, and there is a reference that I would like to take your lordships to close the authorities bundle and go briefly back into the supplementary bundle. This is the original environmental statement produced by the interested parties, and it's page 75 of that document in the supplementary bundle. At the bottom of that...
Did you say page 75?
75 of the supplementary bundle. So this is the original environmental statement produced by the developer and submitted with the application. And that table is a summary of scoping opinions where the examining authority provides its views on the approach that's been proposed for assessing environmental effects for the purposes of EIA. And over the page on page 76, under 4.2.4, you see the subject significance criteria. Comments, those are comments from the examining authority. The scoping report does not set out how a significant effect will be determined for the purposes of the assessment. This should be clearly set out in the environmental statement, and any use of professional judgment to assess significance should be justified. And then see the responses, section 21.3, classification and significance, is dealt with in section 21.3 of the statement, and that basically refers to the first version of the IEMA guidance. So the point there is that the examining authority was observing that you need to explain how you're going to assess significance. My Lord Justice Holgate identified that the second version of IEMA suggests that government policy about goals and necessary action for achieving greenhouse gas emissions reductions is a way that's suggested of contextualising greenhouse gas emissions. And that makes sense. That's how the applicant sought to rely on policy, as my learned friend Mr. Philpott has taken the court to that analysis this morning, and concluded that the impacts from the development would be minor adverse on the basis that the project aligns with policies which aim to support net zero. But the Secretary of State did not adopt or follow that line of reasoning because the Secretary of State didn't conclude a minor adverse impact. Instead, the Secretary of State referred to paragraph 5.2.2 of EN1, and that is the basis, together with the volume of emissions, upon which it said that significance was assessed. And the submission is that that sentence in paragraph 5.2.2 of EN1 does not provide a basis for contextualising emissions. To respond to my Lord Justice Stuart-Smith's question as to whether or not our argument was that that sentence is a deeming provision. Our primary case is it's not. It's not a deeming provision, and therefore it doesn't add anything to an analysis of the impacts of GHG emissions. It does no more than say that they are significant. So it would answer that threshold question at most. It doesn't say how significant or what the impact would be. And if it's taken into account to say, yes, they're significant, and then you have to go on and assess them, then that wouldn't be an irrelevant consideration. We accept that, but it can't and doesn't purport to speak to the question of how significant and what the impacts on the environment will be. The third question is the standard of reasons that has to be applied to the reason conclusion under Regulation 21. Ms. Grogan made the submission yesterday that the AAA regulations do not prescribe a particular level of detail to be given in reasons, but this is a statutory duty to give reasons, and the Supreme Court in Dover and CPRE at paragraph 39 found that the standard of reasons required in the EIA context, not in the context of these specific regulations, but the Town and Country Planning Act, EIA regulations, is the ordinary duty to give reasons set out in South Bucks and Porter.
Did you say paragraph 39?
Yes, it's. I've got
That's
copies
right,
of that
I find
authority.
it.
Yes, it's in the leading planning cases book
Yeah.
at page 473.
Lord Carnwath, yes.
Yes, my Lord Carnwath's judgment. And then the final question that the court must decide is whether in the decision letter the Secretary of State discharged his obligation under Regulation 21(1)(b). The Secretary of State concluded that greenhouse gas emissions are a significant adverse effect. And for the reasons I've given, simply stating that they are a significant adverse effect is not sufficient for EIA purposes. It identifies the significant effect, but not how significant and not what the impact is on the environment. The judge held that the conclusion of significant adverse was based on the volume of emissions and the statement in paragraph 5.2.2 that some effects from the type of development covered by EN1 are significant. And that's the Secretary of State's written case before this court, paragraph 36.4 and paragraph 46.3. The question for the court is whether that's a legally adequate conclusion for the purposes of Regulation 21. In other words, does it explain how significant the effects are and what impact they will have on the environment?
46.3.
46.3
Yeah, and the other reference you gave
is,
was,
and that's at page 48 of the core
Yeah.
bundle, and the other one is 36.4
yeah,
at page 44.
thank you.
And the same submission was made this morning. So is that inadequate? Is that adequate to discharge that obligation? My submission, it's not. The first sentence of paragraph EN1 is just a generalised statement which does not ascribe a particular significance to any specific project. And in addition, even if a relevant consideration, to simply refer to a sentence acknowledging that greenhouse gas emissions are a significant effect, it goes no further than that threshold question. So we're left with the volume of greenhouse gas emissions, and without any contextualisation, any explanation of that does not explain how significant that impact will be. There's been repeated criticism that we are seeking to set up an obstacle course for decision making, which is not a function of EIA. That's not what this case is about. It's not about seeking to impose an onerous burden.
Sorry, you're going too fast.
I do apologise, my lord.
My lords may be able to keep up, but I'm. Could you start that point again?
Yes, there's been repeated criticism of the way that this case is advanced to set up a legal obstacle course for decision making, which is not the function of EIA. That's not what this case is about. The case is not seeking to impose an onerous burden on decision makers. It's about ensuring that the conclusion on significance of effects on the environment is clearly set out in the decision notice, and that it explains what effects are significant, how significant they are, and how they will impact the environment. In a case where the decision maker accepts the environmental statements analysis, or in another analysis put forward in the EIA process, the reasons might be shortly given, but where there's a departure from that analysis, more will be required than simply saying, without any further definition or explanation, that an effect is significant. That could lead to a position where you discharge that obligation by simply listing the effects which are significant. And that's why this, if properly reasoned, this could have made a difference to the case. Because if we knew how significant the effect, that might have affected the planning balance. And even if it didn't, it would still be important, as Lord Leggett explained in his judgment in Finch. It's important because the environmental impact of a project is important. It's important that it's known, particularly in cases where consent is granted, and particularly in cases where projects impact on the climate.
Yes.
Those are my submissions. I have, unless I can assist further, I do have a reference to where we developed the Regulation 21 arguments below, if that's helpful.
Yes, by all means, yes.
Core bundle, page 253, para 21, and core bundle, page 265.
Sorry, core bundle.
Sorry, core bundle,
Yeah,
page 253,
thank you.
para 21, and core bundle, page 265, para 52.
Thank you very much. Thank you very much.
Could I just clarify the law, the way you put it, on the regulation 21 point? Because hopefully you said in the latter part of your submissions that it's an obligation to give reasons, and you equated it to paragraph 39 of Dover.
Yes.
The common law duty to, the judicial explanation of what is the duty to give reasons. Are you saying that Regulation 21 adds anything to what we find in, for example, SAVE? As a matter of law,
Yes.
is Regulation 21 going beyond SAVE?
Going beyond
SAVE,
SAVE.
the judicial explanation of the duty to give reasons.
Oh, the case.
Because you
Yes.
introduced CPR and Dover.
Yes. No, it's the obligation is set out in South Bucks, must be intelligible and
Exactly.
adequate, and must address the principal controversial
Yes,
issues.
exactly.
Yeah,
We know
that's
all
absolutely.
that, but you're not submitting to the court that Regulation 21 goes beyond that.
No.
Right. So what we're talking about is the application of commonly understood legal principles to this particular context, which happens to be dealing with climate change. And your submission is the reasons aren't adequate unless you explain two things. One, significance of the effect, and two, contextualise it.
Yeah, how significant and the impact on the environment.
And we've not been shown any jurisprudence on reason conclusions, anything from the European Commission explaining. It's not some magic term of art. Right.
Well, no, it sits within that context, which explains what you have to do.
Thank you very much. Thank you.
All right, thank you very much. Jeremy, do you have any? Thank you very much. Thank you very much, Mr. Gibson. Mr. Philpott.
My Lord, simply, there's an issue at some point I'd like to raise about the timing of judgment whenever it is convenient.
I can't think of a more convenient time than now.
I'm on my feet, my Lord. The short point is this. Your Lordships will be alive to the fact that this is a matter of some urgency, and indeed there was an order for expedition made at the in the granting of permission to appeal, which we have. It's Lord Justice Lewison's order, which is in the bundle at page 102.
Yeah.
There remains, as you might imagine, urgency in this matter. It's now over a year since the grant of development consent. A great deal of money and effort has been and is being expended in trying to make arrangements for the implementation of the development as soon as possible. A final investment decision was made by the government and the second respondents on the 10th of December last year, enabling the project financing to be released, and as a result of that, contracts have been executed. There is detailed design work being undertaken by the contractors to enable construction activities to commence, and as one might expect in the usual way, as time passes, more commitments are made. So there remains an ongoing urgency, and I simply therefore ask, in that context, whether it's possible to have some indication of when judgment might be likely.
Yes. As soon as we can manage it is the answer, but I don't think we would wish to go beyond that. No. I mean, the points you've made, of course, are important points. We acknowledge that. It's fair to say, however, that there are many projects that come before this court on an expedited basis which have a similar degree of urgency, perhaps, to this project. But we will heed what you've said, and the decision and the judgment will emerge as soon as we can manage it.
Great.
As to that, in a more procedural context, we are reserving judgment. In the normal way, judgment will be provided to the parties in draft in advance of the hand down. That will be the opportunity for the parties to put forward any suggested typographical or minor factual corrections to the draft, with the concomitant requirement that they produce a draft order for our consideration, and any submissions relating to matters not agreed in that draft order. The normal embargo will apply. I stress, as you would expect me to do, the importance of that embargo. It must be heeded. If it is not heeded, there will be consequences. So please note that. That is, I think, all I need to say at this point. Thank you very much. And I thank you all for your submissions, for those who supported you and prepared written submissions with you, and your own oral submissions, and also for sticking pretty closely, well, within 3 minutes actually, to the time estimate. Thank you all very much.
All rise if able.